Good day, future lawyers. This video is part 1 of the top provisions in Civil Law 1. You will also find cases and bar questions for further reference. Now let's get started. Article 2. Laws shall take effect after 15 days following the completion of their publication in the official gazette unless it is otherwise provided. This code shall take effect 1 year after such publication. A law must be published to become effective. Article 2 of the Civil Code provides that laws shall take effect after 15 days following the completion of their publication in the official gazette unless it is otherwise provided. The publication must be of the full text of the law, since the purpose of publication is to inform the public of the contents of the law. Article 3. Ignorance of the law excuses no one from compliance therewith. Article 4. Laws shall have no retroactive effect unless the contrary is provided. As a general rule, laws shall have no retroactive effect. However, exceptions exist, and one such exception concerns a law that is procedural in nature. The reason is that a remedial statute or a statute relating to remedies or modes of procedure does not create new rights or take away vested rights, but only operates in furtherance of the remedy or the confirmation of already existing rights. Article 6. Rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. The doctrine of waiver extends to rights and privileges of any character, and since the word waivers covers every conceivable right, it is the general rule that a person may waive any matter which affects his property and any alienable right or privilege of which he is the owner or which belongs to him or to which he is legally entitled, whether secured by contract, conferred with statute, or guaranteed by Constitution, provided such rights and privileges rest in the individual, are intended for his sole benefit, do not infringe on the rights of others, and further provided the waiver of the right or privilege is not forbidden by law and does not contravene public policy. And the principle is recognized that everyone has a right to waive and agree to waive the advantage of a law or a rule made solely for the benefit and protection of the individual in his private capacity, if it can be dispensed with and relinquished without infringing on any public right and without detriment to the community at large. Article 7. Laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. When the courts declare a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. Administrative and executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. Article 8. Judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. Article 9. No judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Article 10. In case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Article 11. Customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12. A custom must be proved as a fact according to the rules of evidence. Article 13. When the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded, and the last day included. Article 14. Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. Article 15. Laws relating to family rights and duties, or to the status, condition, and legal capacity of persons, are binding upon citizens of the Philippines, even though living abroad. In relation to Article 26 of the Family Code of the Philippines, Article 26 provides that all marriages solemnized outside the Philippines, in accordance with the laws in force in the country where they were solemnized and valid there as such, shall also be valid in this country, except those prohibited under Articles 35, 36, 37, and 38. Where a marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law. The alien spouse can claim no right under the second paragraph of Article 26 of the Family Code, as the substantive right it establishes is in favor of the Filipino spouse. Article 6. Real property as well as personal property is subject to the law of the country where it is situated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property, and regardless of the country wherein said property may be found. Being a foreign national, the intrinsic validity of Audrey's will, especially with regard as to who are her heirs, is governed by her national law, that is the law of the state of Maryland, as provided in Article 16 of the Civil Code. Considering the principle established under Article 16 of the Civil Code of the Philippines, as well as the citizenship and the avowed domicile of the decedent, It goes without saying that the defendant was also duty bound to prove the pertinent laws of Maryland on the matter. Article 17. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgment promulgated or by determinations or conventions agreed upon in a foreign country. The joint will may produce legal effect in the Philippines if it was validly executed in accordance with the laws of the U.S. To be given legal effect in the Philippines, it must be probated in this country. Since the will was executed abroad by aliens, it must comply with Article 17 or Article 816 of the Civil Code. Under Article 17, the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. Chapter 2. Human Relations. Article 19. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 19, known to contain what is commonly referred to as the principle of abuse of rights, is not a panacea for all human hurts and social grievances. Elsewhere, we explained that when a right is exercised in a manner which does not conform with the norms enshrined in Article 19 and results in damage to another, a legal wrong is thereby committed for which the wrongdoer must be responsible. Article 20. Every person who, contrary to law, wilfully or negligently causes damage to another shall indemnify the latter for the same. Article 21. Any person who wilfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Article 20 pertains to damages arising from a violation of law. Article 21 refers to acts contra bonos mores and has the following elements. 1. There is an act which is legal. 2. But which is contrary to morals, good customs, public order, or public policy. And 3. It is done with intent to injure. A common theme runs through Articles 19 and 21, and that is the act complained of must be intentional. The existing rule is that a breach of promise to marry per se is not an actionable wrong. This notwithstanding, the Code contains a provision, Article 21, which is designed to expand the concept of torts and quasi-delict in this jurisdiction by granting adequate legal remedy for the untold number of moral wrongs which is impossible for human foresight to specifically enumerate and punish in the statute books. Article 22. Every person who, through an act of performance by another or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground shall return the same to him. Article 23. even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. There is unjust enrichment when a person unjustly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. The principle of unjust enrichment has two conditions. First, a person must have been benefited without a real or valid basis or justification. Second, the benefit was derived at another person's expense or damage. That is it for part 1 of the top revisions. Thank you so much for watching, and please subscribe and also stay tuned for part 2. Have a nice day.